This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
Dish and Dirt, the #1 real estate podcast in South Carolina. I'm your often opinionated but rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia, South Carolina offices of Blair, Cato, Pickering, Castleton, the first week of June 2025. So before I begin our big show this week, a couple things to update you on. Sumter office now open. Our Greenville Commons office now open, and we will be announcing the location of our Spartanburg office. That's right, we have a new West Side office in Spartanburg coming, and we'll announce that in the next couple of days. And our Myrtle Beach permanent office is coming right along. Sheetrock's in, the mudding and everything's going up, so they should be painting very soon. So we are getting very close to having all of our 9 offices fully opened, operational. We're very excited about that. So if you have a closing in any of those areas, let us know. We'd love to help you out in any of the locations where Blair Cato is. And if you have a closing that you want to do online, we can always do closings via Teams, and we can get to you taken care of regardless where you are in South Carolina. So very excited about that. Now let's talk about our show this week. I've been getting phone calls for years on this scenario. It's not uncommon. It's probably not uncommon to you. A real estate agent will represent a seller in a transaction. The seller will do a seller disclosure. Buyer will do inspections. They may find something, they may not find something, but typically they'll find a small item. It'll be negotiated as repair, whatnot. It closes. After closing, the buyer of the house starts doing more work on the house, finds something that's broken. And now they want to sue the real estate agent and the seller, saying that somehow the real estate agent was complicit or either participated in a cover-up of some form. And that happens all the time. And it doesn't matter whether the inspector found damages and they were negotiated as repair, or whether or not they just look at that seller disclosure, they find something on the disclosure and say, this should have been disclosed. You didn't disclose it. So now the real estate agent somehow is 100% responsible for paying for that item. I can't tell you the number of times I get this phone call. Got it last week. I've testified as an expert on exactly these scenarios. And this is one of the main types of cases we get. I always find it interesting that buyers just don't believe they have any responsibility to find anything wrong with the house or do any inspections, and that when something breaks in the house, somehow it's just not bad luck. They're always looking for somebody else to be responsible. And we know this to be the case. I think the number's in the 70s or 80% now of people who believe it's somebody else's responsibility to warn them of wire fraud. I mean, we are in 2025. Why does anybody need to be educated or warned of wire fraud? How do you not know that fraud, wire fraud, real estate fraud, all of it is a very strong possibility? I don't know why we think that somebody has to warn us of that. We should just know that because we breathe air. But somehow our society, particularly since COVID, has gotten this idea, it's never my responsibility. It's always somebody else's. I also find it very interesting on most of these cases that the buyer has gone into the house. They've had a home inspection, a termite inspection, a heating and air inspection. They've been in the house 5, 6, 7 times with their real estate agent. Compare that to the listing agent who went to the house for 45 minutes to an hour when they met with the seller originally to do the listing. That might have been the only time they've ever been in the house outside of maybe taking some photographs. But yet the buyer who can never find these damages through multiple inspection companies somehow believes that a real estate agent who went to a listing meeting somehow knows it all, knows the whole history of this house for the last 30 years. I've seen that in several of the cases I've been an expert in, where there will be damages that had been 4 or 5 years old and had been repaired, and yet 3 inspections didn't find anything. The buyer being in the house 15 times didn't find anything. But when our listing agent went to the house 45 minutes to an hour to do the listing presentation, somehow all of this bad stuff should have been gleaned just from sitting in the house. It somehow comes into your listing agents, I guess, through osmosis, and somehow you just know it. You should just know it. But that's exactly how it is. It's nothing different than that. That's exactly how these cases work. So what I'm going to do today is I'm going to give you the secret defense. I'm going to look behind the curtain. You get to look in this mind of Gary in some sense to see how a real estate agent can defend themselves against this crap. And that's what it is. It's basically crap. It's lawyer crap. It's another example. Too many plaintiffs lawyers in the world. Everybody's got to sue somebody for something. And I say this as a lawyer. I used to do litigation, but I got so fed up with this kind of stuff that I just couldn't stand it anymore, and I quit doing it. And I'm a much happier person, even though you probably can't tell from the rants on my podcast, but I am a lot happier person since I stopped doing that. But the good thing about it is there are three big defenses that every real estate agent has. Two of them are cases determined by our courts in South Carolina, and one of them is a statute written by your legislature. So there are three huge defenses, and I want to go over those defenses with you today so that you understand where your defense lies, so that if somebody starts bringing this matter to you, because that's usually how it happens, they'll start emailing you, a lawyer will start writing you letters and so forth, we'll give you what the defenses are. Now, if you ever get to the point where a lawyer is writing you a letter on one of these matters, I strongly, strongly advise you to hire a lawyer to help answer. As I told somebody the other day, you could hire a lawyer maybe for $500 or $1,000 to respond of why what the plaintiff's lawyer is saying does not apply to you as a real estate agent, or you can wait till you get sued and pay that same lawyer $5,000 to $10,000. So I would rather go ahead and try to nip these things in the bud versus waiting for them to evolve into some much larger case. I believe a lot of times plaintiffs' lawyers don't really understand what real estate agents do. Heck, I don't think closing attorneys understand what real estate agents truly do. So when they don't understand what you do, they start making assumptions. In fact, I think a lot of these plaintiffs' lawyers who sue you don't even know that 40-57 even exists, and they don't know the first thing about these cases I'm going to talk about. So these are your best friends. These cases, the statute is going to be your best friend. So let's talk about it. The first case we're going to talk about that is really one of the best defenses a real estate agent could ever have is the McLaughlin versus Williams case. It's McLaughlin versus Williams. Now, if you want to read more about the case, you want to actually read the case, all you have to do is go to Google, type in McLaughlin versus Williams. McLaughlin, I think it's pronounced McLaughlin, but type that in, it'll come up. You can click on it, read everything about it. So I'm going to try to give you the bullet points of the facts of the case so you can see it's very similar to a case that you probably have dealt with in your life. Talk about what the plaintiff sued for, but the most important part, what did the court say in response, and what protection does that give you in the future if somebody tries to come at you for one of these issues? I have always loved this case. I cite this case all the time, not only to real estate agents, but to lawyers who call me wanting somebody to look at it as an expert. I will cite this case when a lawyer's call me complaining about something the real estate agent did. Did you look at the McLaughlin case? Does it provide you a cause of action or not? In most cases, it doesn't. So it's a very good case for your defense. It's a 2008 case, 17 years old. McLaughlin was a buyer. Williams was a seller. The agents were Coldwell Bankers, Shakora Real Estate, which was the buyer's agent, and Dunes Realty, which was a listing agent. It was down in the Georgetown, Myrtle Beach area. A seller disclosure form was done by the seller. Upon receipt of the disclosure form, Kinsmore, who was the agent at Coldwell Banker, she noticed that several of the items were left blank. Some had no explanations and indicated there's possible problems with the subject property in her mind. So Kinsmore requested a more complete disclosure, which a smart real estate agent would have done, but neither Dunes nor Williams provided one. She noticed that the disclosure wasn't complete. She went back to the listing agent and said, this isn't complete. Please update it. Please give us more, which they didn't do. On May 15th of 2003, Kingsmore showed the disclosure statement to McLaughlin and advised him to get a home inspection to ensure there were no major defects with this property. McLaughlin even initialed the disclosure statement, signifying that he had seen it and reviewed it. So the McLaughlin, the buyer, then goes out and hires U.S. Home Inspections to perform what was called, quote, a whole house inspection of the subject property. Following that, McLaughlin did get a written inspection report, which did indicate moisture damage to the exterior of the subject property. There was also a CL 100 done, and it indicated the presence of wood-destroying fungi and wood moisture content of 28% or more in the first floor. On May 18th, McLaughlin closed on the property, took possession, and 6 weeks later, of course, we all know what happens. McLaughlin learns of defects in this structure relating to water intrusion, and now they're ready to file a lawsuit. And that's what they did. They sued for fraud and negligent misrepresentation. What you need to understand about the allegation of fraud, that the real estate agent and the seller committed fraud, or the real estate agent and the seller were negligent in their representation, is that one of the elements that the plaintiff has to prove in court was that they had the right to rely upon that misrepresentation or upon that fraudulent statement. If they can't rely on that statement, it's such an outlandish, ludicrous statement that nobody in their right mind could rely on it, then you can't win the lawsuit for fraud or negligent misrepresentation. But what you have to look at, and that's what the court does, was the seller disclosure a statement which could be relied upon? In the complaint, McLaughlin basically says the disclosure statement was a misrepresentation and said that they reasonably and detrimentally relied upon it. And in fact, what they said was that the defendant, which include both the listing agent brokerage as well as the selling brokerage agency, as well as the seller, all had statutory duties to ensure that the seller's disclosure statement was in compliance with statutory law. So the question in this case becomes focused on the disclosure statement. Was it a misrepresentation? And was McLaughlin entitled to rely on what was in there or what was omitted from there? It will surprise you what the court said. I was very surprised when this case came out back then, and I love it to this day. The court said there can be no reasonable reliance on a misstatement if the plaintiff knows the truth of the matter. Thus, if the undisputed evidence clearly shows that the party asserting reliance has knowledge of the truth of the matter, there's no genuine issue of material fact. Let's break that down for a second. What this is saying is you can't know something is wrong with the house and it wasn't disclosed on the disclosure statement, close, and then go back and sue because it wasn't on the disclosure statement. You don't get to close and then go, gotcha. We don't have these gotcha moments in law. You can't know there's a problem, take advantage of that problem by closing it, and then suing for that problem. So if you have knowledge of the problem, you either don't close and have them walk away, or you close and you accept it. What the court pointed out was the information that was contained in the home inspection report, as well as that CL 100, clearly showed the existence of water damage in the property. There was no argument about that, including the testimony of McLaughlin and Kinsmore also stated such information placed on them some notice of potential moisture problems. So ultimately what the court determined was based on this information, no reasonable jury could conclude that McLaughlin had the right to rely on the seller disclosure statement. And so therefore the whole case is gone. If you can't rely on it because you had evidence to the contrary, you cannot try to claim your reliance on it and close and sue later. McLaughlin now tries to argue, well, the level of the knowledge could be gleaned from the information. You know, it says it, but doesn't fully say it. And he even argues that the home inspection report does not indicate water damage to the locations within the interior portion of the house. They actually noted outside the house, and therefore there should be no issue as to having a home inspection report. They also claim shouldn't preclude them from relying on the seller disclosure form. And then they even tried to say that the CL 100 form only indicated a presence of wood active fungi, which was not really even an issue in the case. But the court disagreed. That is a massive victory because the court says it doesn't matter whether you could sit here and look at the information you have and pinpoint exactly where that issue is. If you even have generalized information as to the issue, then you have issue. And so if you look at in this case here, there was water intrusion issues noted in a report in a completely separate part of the house. They found water issues in another section of the house. And the court says the fact you knew there was any water intrusion damage at all in the house put you on notice. And therefore you had duty to do further inspections. You can't close now and say we didn't know. And what the court said, I'm going to read some of this because I think some of this language is very important and this will go to help you in the future. Although the disclosure statement indicated Williams was not aware of a malfunction or defect due to water seepage, leakage, dampness, or standing water or water intrusion from any source in any area of the structure, the home inspection report clearly informed McLaughlin that there was some moisture damage in various locations on the exterior of the subject property. The CL 100 reported active wood destroying fungi and a moisture content of at least 28% below the first main floor of the house. The CL 100 explicitly noted fungi damage to wood, which is commonly called water damage. Both the home inspection and the CL 100 clearly show McLaughlin had information that directly contradicted the seller disclosure statement. So in sum, the home inspection report and the CL 100 clearly illustrated to McLaughlin the information indicated in the seller disclosure was there. There was moisture damage. They had knowledge that directly contradicted it. So as a matter of law, they failed to establish the ability to rely on that information. That is very good. What we can take away from that as real estate agents and as lawyers defending real estate agents is that they have any inclination or any indication of that damage. They can't later sue you. So it's important to get these home inspection reports. It's important to keep these in your file because that is where they're going to come try to get you. So if we have any indication in any inspection report that that damage was already there was some way they should have known it, then that will help bar them from bringing that case. Another part of this case is also very helpful to us, and this is what a lot of plaintiffs' lawyers clearly don't understand, is that they believe the South Carolina Residential Property Condition Disclosure Act imposes some duty on the real estate agents to make sure that it's 100% accurate. And if it's not 100% accurate, somehow you're responsible, I guess, for not browbeating your seller to make sure they don't tell a lie. Because I don't know how they would know if your seller lies. How are you supposed to know that? You're not a home inspector. You didn't do a home inspection, but yet somehow you are supposed to glean from your seller's actions that they were acting dishonest. The real estate licensee, whether acting as a listing agent or selling agent, however, according to the statute and according to this court, is not liable to the purchaser if the owner provided the seller with a disclosure form, which is what happens in all these cases. It contains a false, misleading, incomplete information, which happens in these cases. And here's the key. The real estate agent did not know or have reasonable cause to suspect the information was false, incomplete, or misleading. So in order for them to even get past this aspect, they have to show that you knew or should have known, which, by the way, the standard actually for agents is actual knowledge, and we'll get to that in a second. But this, even back in 2003, when this case happened, that was the standard. They had to show that you knew or somehow should have known. It wasn't just there was damage and therefore you had strict liability. We're going to get in a second to this Isaac case, which actually changes that and it actually solidifies that protection more for you in just a minute. But what we can take away from this McLaughlin case is if they have any knowledge of this damage, they have knowledge. They can't unknow what they already know, and they can't sue you later trying to claim, I knew some of it, but I didn't know all of it. You need to know this case. You should go read it and understand this case is important. And this was also one of the beginning cases that really started limiting your liability under the disclosure. This is where they really started talking about, in order for you to be liable, that you don't have a duty to ensure that all the information is accurate. They have to show that you knew about it. So let's now talk about the Isaac and Kopchinski case. Now, we have done a full podcast on this, and I can even put a link to that in the show notes here. So if you haven't had a chance to look at the Isaac Kopchinski case in full, it's an amazing case. It's one of the best things that's ever happened for real estate agents. And that case, together with McLaughlin, does provide you a lot of defense. So let me give you the Reader's Digest version of this case. So Isaac's a buyer in a residential real estate transaction, and he sues the seller's real estate agent named Kopchinski for failure to disclose high moisture levels in the crawl space and mischaracterizing a wood infestation report as good. In this case, I'm going to give you the real short version. The seller lists their home for sale with Kopchinski as a real estate agent. They did the seller disclosure form. They stated that there was no current wood-related issues. They had a buyer agree to buy the house. During inspections, they discovered crawl space concerns through a home inspection, and it stated they should have further examination, which Stark's exterminators came out, and they did other inspections, and they found there was elevated moisture and wood decay fungi. Stark recommended significant repairs. I think it was about $4,000, $5,000 range. The sellers, however, cheaped out, and they hired a handyman who did the work for like $700. Subsequent pest inspection done by for the first buyers found the elevated moisture, but no active wood-destroying fungi. At this point, however, even after the work's done, the sales falls through because of an appraisal issue for unrelated issues to this damage. They went back and started marking the property again to the new buyers, which was the Isaacs. And the sellers shared the original disclosure form, which they did not amend, so it still has no current wood infestation on there. However, they did attach the home inspection and stated that repairs had been made. Isaacs then got under contract, and they did their own inspections. They got a CL 100 from the same company that the previous buyers had used, but they showed no current issues. So the company who found the damages in the first closing, which fell through, was the same company who came back and did the inspection for the second. They clearly knew all of the information that was out there, and they did not find any issues. Now, after closing, as you would expect, this happened in 2018, the Isaacs experienced flooding, and they had Stark come back out and inspect the crawl space, and this time they had high moisture levels, active and non-active wood fungi. They had wood damage. And so, of course, the Isaacs didn't only sue the sellers, they also sued Kopchinski, the real estate agent, for misrepresentation, negligence, and other claims. This case is very important to you as a real estate agent because this is going to go to the heart of the matter of the seller disclosure. The court looked at this case and they found that Isaacs did not rely on Kopchinski's statement about the June CL 100 being good, and that the Isaacs themselves actually had a duty to inspect the property themselves. Therefore, the court said Isaacs could not establish justifiable reliance. There goes that word again, that reliance, which was the necessary element of misrepresentation. The court also held that the South Carolina Residential Condition Act does not create a private cause of action against a real estate agent, only property owners. That winds up being huge moving forward. So let's break this down a little bit. First, what they said, the court, and these are very important statements to always be able to keep in your back pocket. There is no liability for casual statements, representations as to the matter of law or matters which plaintiff could ascertain on their own in their exercise of due diligence. So these throwaway statements such as it's a good house, it's a solid house, and nothing's wrong with the house, all of those casual statements, if the buyer could do the inspections themselves and find their own experts and have their own due diligence done, then the liability doesn't exist. A real estate licensee does owe a duty to Isaacs to be truthful. So a real estate agent does own a duty of truthfulness to the consumer here, the buyer. However, the court said a licensee is not obligated to try to discover latent defects or to advise parties on matters outside the scope of their license and their expertise. No cause of action may be brought against a licensee who has truthfully disclosed to a buyer a known material defect. Very important statements there. It starts limiting your liability. You don't have to go outside of your knowledge, outside of your expertise. That's what these inspectors are for. If you truthfully disclose something, you can't later be sued for it. We've always talked about this on disclose. Furthermore, one of the probably most important things that the court said is that the buyers have a duty to inspect the property. And they cited 2750-80. Court said, quote, taking together these sections provide that a real estate licensee does not have a duty to inspect or investigate the physical condition of a piece of property for the purpose of confirming or denying statements made by a seller in a disclosure statement. Boom. You have a right to rely on the seller disclosure statement. You don't have to independently go investigate. Rather, the legislature placed the duty of performing such investigation squarely on the buyer's shoulders. Boom. Again, bam. This is great news. All of this is good stuff that this buyer, if they're going to rely on these statements, they have a duty to go out and investigate them to make sure they're true and accurate or false. You, the real estate agent, does not. They provide you the information unless you have absolute knowledge that it's a lie, then you don't have a duty to inspect. Now, if you're sitting in the house and it's pouring down rain and it's leaking like a sieve and you don't say something about that, that's a whole different ball game there, guys. We all know that. These hidden defects and things that somehow you're supposed to know, that doesn't create a cause of action against you. In fact, what the Supreme Court said was the Disclosure Act creates a private cause of action against an owner who knowingly violates or fails to perform a duty under their act. But in contrast, the Disclosure Act provides immunity for real estate licensees when they did not know or have reason to know, and therefore it does not create a private cause of action against them. So as I mentioned in that previous podcast when I talked about this was an outstanding ruling by the court. For years, we have been saying that at the Real Estate Commission that the seller disclosure was a shield for real estate agents when in fact it was a sword that was being used against them time and time again. Now, that's all changed. This clearly says it is a disclosure, there's no private cause of action, so they can't sue you on it. In fact, since this case came out, I've had two different lawyers calling me on this exact issue, asking me to be an expert. And I said, have you seen this Isaac case that just came out? And it literally guts the plaintiff's case. So I'm very excited. These two cases by themselves provide you so much protection. Now let's talk about the third protection that you have. In the new statute, 4057-350, we're talking about G1. Maybe this is your best friend of all of them. This might be even better than those two cases. G1 says, 350 G1, a licensee shall treat all parties honestly and may not knowingly give them false or misleading information about the condition of the property which is known to the licensee. Look at that language there, may not knowingly. So you have to have actual knowledge. You have to be intentional about it. If your client tells you something and you have the right to believe it, and you do believe it, and the Supreme Court's already said you have no duty to go out there and inspect it and try to find whether it's truthful or not, you have reason to believe what your client's saying, you cannot be in trouble for that if you don't knowingly know it's false or misleading. If I don't know that what my seller told me was in fact false, then I cannot knowingly give false or misleading information. Very good statute. It also says a licensee is not obligated to discover latent defects or advise parties on matters outside of our scope. Supreme Court said the same thing. And then this is my favorite thing. Notwithstanding another provision of law, no cause of action may be brought against a licensee who has truthfully disclosed to a buyer a known material defect. But that means here, guys, it doesn't matter whether that item wound up being truthful, it's that you truthfully disclosed it. And so what this is saying is if your seller tells you something and you have the right to rely on them and you truthfully provide that information, you don't taint it, change it, puff it, you just give it out, truthful disclosure, you can't be sued for that if that information turns out to be incorrect. It's only when you knowingly do it that it's incorrect can you get in trouble. And then lastly, G3, a licensee, the real estate brokerage firm, and the broker in charge are not liable to a party for providing the party with false or misleading information if that information was provided to the licensee by the client or the customer and the licensee did not know the information was false or incomplete. That right there, my friends, is your biggest defense. You have the right to rely on what's given to you by your client or your customer unless you know false or incomplete or misleading. Not should have known. It's actual knowledge. So all these plaintiffs, lawyers that want to go out and sue you and say you should have known it, that is not the standard. So when them starts calling you and starts saying you should have known this was false, you should have known that there was damage to the house. Sorry, Mr. Lawyer, but under G350 G3, 4057 350 G3, client and customer gives me information. I have the right to rely on that. I have the right to pass that information along unless I know it's false or incomplete. What evidence do you have, lawyer, that I had knowledge that was false and incomplete information? They don't have it. They won't have it. So guys, these three cases are your biggest defenses right now. Somebody comes to you on a seller disclosure issue or a disclosure issue or damages after the closing. It's McLaughlin versus Williams, it's Isaacs versus Kopchinski, and it's G1, G3. Those right there, those two cases and that statute are your best friends. That is what you'll need to defend yourself. So go look those cases up, go look those statutes up, read those, be familiar with them and understand. Now, do not take this podcast as a license to do things you know are wrong, because remember, it's whether you know or don't know. So if you know something and you hide it, you cover it up, you're party to the obfuscation, you will get in trouble for that. That is not what these cases are about. That's not what the statute's about. They're about doing it right, but you're not held liable for things you don't know. You know it and you hide it, cover it up, misstate it, you will find liability there. My last piece of advice, again, if you get in this situation, find you a lawyer to help you. You do not want to try to do these matters on your own. Do not go ask your closing attorney unless your closing attorney knows that 40-57 exists. Most real estate closing attorneys do not know what you do as a real estate agent. They will not know about the McLaughlin case. They will not know a thing about Kopchinski or Isaac's case. They're not going to know anything about 40-57. Just because you can do a loan closing doesn't mean that a closing attorney has a clue about what real estate agents know and what you do for a living. My advice, and this isn't meant to be a free commercial for my friend, but David Anderson over at Richardson Plowden, one of the best in the business. David Haller down in Charleston, one of the best in the business. These guys know how to defend real estate agents. They know the statutes, they know the cases. And I have many conversations with these guys when I'm trying to figure things out. These guys know what they're doing. That's the kind of lawyer you need representing you. Hope y'all have a wonderful weekend. I appreciate y'all liking, listening, and sharing Dish and Dirt with others and making Dish and Dirt the #1 real estate podcast in South Carolina. Y'all have a good weekend. Come back and see us next week.